there's so much demand for legal service and so much demand that goes unmet. I think there's plenty of room for everybody.
Today on Law Next, my guest is Ralph Baxter, who spent nearly a quarter century as chairman and CEO of the law firm Orrick, Herrington, and Sutcliffe, leading its growth from a regional law firm to one of the world's largest and most prominent, and who now devotes himself to inspiring positive transformation in the way legal services are delivered globally. This is Bob Ambrogi, and you're listening to Law Next, the podcast that features the innovators and entrepreneurs who are driving what's next in law. We'll get to today's interview in just a moment. But first, let's hear from the sponsors who generously support Law Next. And now, on to this week's interview. Ralph Baxter, how are you today?
I'm doing great, Bob. Thank you for having me.
Thanks. And we are sitting here face-to-face live in a conference room in Seattle where we both happen to be, and we're able to get together and chat. So happy to be able to do that. And heck, let's start with the big news. Here we are talking on a podcast. You're about to launch your own podcast, right?
Yes, I'm very excited about it. I'm going to co-host a program, Law Technology Now, with on the Legal Talk Network. My participation will begin. We're scheduled to begin in October, and I'm very excited to follow in your footsteps here and see if we can't help people in the world understand how law works and how it can work better for them.
Not just in my footsteps here. I actually spent a little while as one of the hosts of that program. Monica Bay started that program a number of years ago, and I stepped in for a while. And I know Dan Lina is also doing it. It's one of my favorite podcasts to listen to. So I look forward to that. When do we get to hear your first? When are you up on the airwaves, so to speak? Well,
we have some things that are going to be up this month, but I'll start hosting in October.
So, Ralph, as I said, from 1990 to 2013, you were the chairman of Orrick. You left there in 2013. Since then, if I can just rattle off a few of the things you've been doing. You are chairman of the advisory board of Thomson Reuters Legal Executive Institute. That's right?
Well, yeah, I did do that.
You did do that. Okay. You're on the board of directors of INTAP. That's right. Still a thing. Legal advisory board of LegalZoom.
Right.
You were on the boards of directors of both Lex Machina and Ravel Law before they got sold to Lexis. Is that right? Yeah. Senior advisor and member of the advisory board of Stanford Law School Center on the Legal Profession. Fellow and senior advisor to Codex at Stanford. Member of the advisory board of the Harvard Law School Center on the Legal Profession. Member of the advisory board on the Georgetown Law School Center for the Study of Legal Profession. So my question is, you essentially retired in 2013 from the firm. What is driving you? What's driving you to be involved in all of these programs right now and to be doing all this stuff?
I know we can do better. We, all of us who are involved in legal service, can do a better job of meeting the needs of people who depend on law for their personal issues and their business issues and their public interest issues. I know we can do better. This motivated me from the very beginning. From the day I became a lawyer, it seemed clear that we could do it better than the old-fashioned ways. When I was a young lawyer, I wondered why anybody would pay me the amount of money that was being charged for me to do the kinds of tasks I was doing. Surely there was a more efficient way we could do it. And when I left Orrick, first of all, I had no interest in retiring, and I deny I'm retired, right? But it was time for me to change my focus from what I was doing with one law firm, one enterprise, to something broader. But I'm really driven by that. Law is more important than it ever has been in the history of humankind. It's in everybody's life, and it's in every business's business, and it's in every NGO's affairs everywhere. And it's not being delivered in the way that the clients need it to be delivered. It's too slow. It's too opaque. It costs too much. It's not really responsive to the actual problems or objectives of the clients, or it's not as responsive as it could be. And I think I can make a difference. I was blessed to have this career that you've rattled off here in the introduction, have all that time in big law, in the course of that to meet with so many leaders of so many organizations, the law firms, the corporate legal departments, and the public interest organizations. And so I think I'm in a position to help, and that's what I'm trying to do. And so those organizations with whom I'm working and some others are different ways that I think I can stay informed, understand what the problems and the challenges are, but also evangelize a message about how we at every stage can do this better. As most things in life, we're all in this together. So everyone needs to do a better job. Actually, the clients, the big corporate clients, need to do a better job of organizing the way they consume legal service, the way they interact with the law firms. They can do better. But the law firms themselves are the ones who have the most opportunity to change for the better.
You know, during your years at Orrick, you had a reputation as an innovator. The firm has a reputation as an innovative firm, thanks, of course, in part to you, and it's continued to be an innovator since you've left there. But I think of your time there as focused on building up a big firm serving big clients. And now I talked to you a number of times. It seems to me that your interests are much broader. You're looking across the entire legal landscape of those who are not necessarily being served well by this system. I'm wondering what your experience at Orrick and over those years equips you with to address these broader problems. What do you take from what you learned at Orrick, and how do you expand that more broadly to the population as a whole?
Well, fundamentally, I learned how it works. I know how a law firm, big law firm, and you're exactly right about what my career was, how it assembles resources, how it thinks about taking those resources to serve the clients, how it thinks about its economics and the issues that motivate it, which are often ones that border on being inconsistent with the interests of the clients, the billable hour, for example. So I learned how it fundamentally works. And I didn't know when I left Orrick exactly how far the reach would be of what I might work on, what I might try to influence. So I pushed myself out of my comfort zone, and it was really pretty painful at the beginning, getting myself into situations that I didn't know anything about, I never experienced. There's so much of the world of law that if you are just in a big law firm all those years, you really don't learn about. You don't know the real dynamics of it. But as I've gotten into these different dimensions, so access to justice, smaller law firms, for example, two different dimensions I wasn't involved in, the issues are pretty much the same. It's the economics are quite different, the resources are quite different, but the issues are pretty much the same.
Yeah, I mean, are they that? I guess that's what I'm trying to understand is and ironically, I'm on the other side of the coin in that I've never worked at a big law firm. I've only worked in a small practice. I've been a solo much of my career. And even there, I think there are problems of the sort of the really lower end of the spectrum, the pro se litigants who are going into court without a lawyer at all, or the people who the system is just not even reaching them really in any effective way. Right. I think a lot of lawyers just don't at all grasp what that's like for those people. The questions they have. I mean, it was the interview I was talking to somebody the other day who was. I was hearing an interview with a guy on NPR, actually, a guy from the rock band The Slants, which had the Supreme Court case this year over the registration of the trade name The Slants, and he was saying, it's so surprising to me that I was a party in this suit, and here I was in the Supreme Court, and I wasn't allowed to talk. Mm-hmm. Like they don't understand mm-hmm. the way lawyers do how the system works. Mm-hmm. So, how do we? How do we begin to address that? I mean, where do you see the need most urgently, and where are you focusing your efforts?
Well, there's so much. So you touched on one of the most important problems in access to justice, that people, ordinary citizens, don't understand how law works at all. I mean, one of the things we're going to try to do with the podcast, seriously, is to try to broaden the audience and help more people understand how law fundamentally works. But that's a detail that needs to be addressed, and that's a common sense problem. People don't. So just staying with that example that you just shared, people more often than not don't even know they have an issue that is a legal issue. They know they got booted out of their apartment, but they don't see that as a legal issue. The problem is they need someplace to live. And whatever the issues are in immigration, family law, and so on, they may know that there's a court they've got to go to or something, but fundamentally they know that they want to care for their children or they want to stay in the United States or whatever the issue is. And in big law, what we always tried to make sure our lawyers understood is that the clients, in the biggest of matters, don't think of those things as legal issues. Those are business issues. They're in a dispute or they're doing a transaction. That's what matters to them. And the law is an element of how they get to where they want to get. And that's really what the reality is for someone who has been evicted from her apartment. That's the reality for someone who's being sent back to the country from which she came. And so we have to bring law to that, and we need to have a strategy. When I first was elected at Orrick, I sat down and tried to figure out how can we do a better job of delivering the service our clients need on the terms that they want them in the places they need us and all of those things. And there was no rule book for that. We just figured it out step by step. Well, that's what we need to do with access to justice. That's what we need to do with more sensible programs within the corporations to consume legal services. It's what we need to do in legal education, which has a huge need for change. Yeah. But it's just common sense. We know what the issues are. How do we proceed, knowing what the 21st century enables and permits? How do we proceed to get better service to these people who need it? And whether that's the biggest corporation in the world or it's the poorest citizen in Seattle, the common sense question is, how do we get legal service on terms that make sense to the person who needs it?
Yeah. You were a 43-year-old labor employment litigator when you became chairman of Orrick. I don't know whether you had any management experience up to that point at all, but what was the mandate for you? How did you come into that position, and why you? Why did they want you in that role?
So I thought about that at the time, and I concluded that they must have wanted change, because back then law firms did not elect 43-year-olds to run the firms. It's now more common, but back then it was normally someone at the very end of his career, not a his or her, but his career, and someone who came from the corporate department as likely as anything. I had built the labor and employment practice at Orrick. So I had done that, and we had it up to about 12 lawyers when I was elected. But I had done that. But I had done things differently in building the labor and employment practice. Orrick didn't have one when I got there. And so we created a new department. We made it successful, and we were really representing important companies on important matters, and it was going very well. And the firm had been through a very difficult time 2 years earlier than I was elected. There'd been a big change in the law affecting our biggest law practice.
Is that municipal bonds?
Yeah, that was the public finance practice, and the tax exemption for a lot of the transactions that we did was eliminated, and so it changed the market. And suddenly there was a difference in demand for our services. It was a short-term dip, but I think everybody in the firm got the idea that these forces external to us can be perilous, and so we need to position ourselves better for a future in which there's likely to be more and more change. And right at that same time, law firms from elsewhere in the United States were coming into the San Francisco Bay Area market, where Orrick was entirely at that time, or nearly entirely. And you could see we're facing different competitive firms coming into our market from New York and from Los Angeles and so on. You could see that the nature of the needs of the clients were changing, and they needed service in areas that we really didn't do at the time. So I concluded that must have been it. It must have been that the partners saw the need to change, to adapt to the times, and they selected a relatively young partner who had built something that was new in the firm, and put him in charge.
Yeah, I was thinking about the fact, because it's hard to research your name without finding the word innovation attached to it all over the place. I mean, you've literally received honors as an innovator individually yourself and the firm. And I was thinking about the fact that back at that point when you became chairman in those years, innovation wasn't a word that got thrown around a lot, or disruption, or some of the words that we use now.
Right.
I mean, did you think of yourself as innovating, or did you think of yourself as building the firm? I mean, how did you look at what you were doing?
Well, I thought of myself as a change agent, not in those words. Yeah. There were no buzzwords for this.
Right.
I mean, I really, what we just talked about, I literally thought through. Why me?
Yeah.
And the only conceivable answer was change. Because I was someone who had done something differently in my short time at the firm. I'd been there 10 years total at that time. And so that's how we thought of it, as change.
Yeah.
Not innovation.
Change what? Change how?
Well, so change, again, really just apply common sense.
Yeah.
So here we are. This one practice that's so important to our firm has been diminished. So now, what do we do? And so, well, we'll just think it through. Just like you do, you get a new dispute, and you're a litigator, you think through, how are we going to win this?
Right.
What does that look like? And then what are the steps we need to take to get from here to there?
Yeah.
And so that's what we did. Some of it was obvious. So we needed to diversify our practice areas. We were too dependent on one.
Right.
It's still a great practice at Orrick. It's a fabulous practice, but it was better for us to be diversified. We were too dependent on the San Francisco Bay Area market, and all these other people are coming in, so we better establish ourselves in other places. And some of that was obvious. The early strategic issues, well, they weren't obvious, but they were knowable. You could figure them out and go for them. The things we did later were harder. Thinking about how do we change the way we go about delivering legal service. The early decisions we made were basically strategic.
Expand to other cities, expand overseas at some point, expand your practice areas, those sorts of things.
And the sector. We progressively got more and more focused on industry sectors, and Orrick's very clear now for the three sectors that it represents. So those were strategic questions. And the other thing we did was recognize that we had to be aimed at one part of the market or another. So we aimed at high value engagements where there's a lot at stake for the clients and where the lawyers make a big difference. And that decision affected pretty substantially what kinds of cases, matters, transactions we would take on and which ones not. But then we turned to, once we had ourselves on the road to having a sound strategy for the future, then we turn to the infrastructure kinds of questions. But to the question you asked about thinking of ourselves as innovators or disruptors, we didn't think that way at all. Yeah. It was about change. And I'm not sure that today it's all that healthy for everybody to think that their objective is innovating.
Yeah.
I think the real objective needs to be making things better, whatever it is you're doing, serving the clients better, making the career path for the associates more rewarding so they want to stay in the firm. Whatever the issue is, it's about making the outcomes better, making the experience of the clients and the lawyers better, whatever it is, it's making it better. And I think we sometimes get ourselves focused on the wrong issues when we think of it as just innovation for innovation's sake, or disrupting for the sake of disruption.
Yeah. Well, by that measure, you consult with law firms now. How are law firms doing in making it better? Let's start with making it better for the client. How are law firms doing? How do you grade them on how much progress they've made in improving client service and thinking and understanding, as you said earlier, the client's business and the business goals?
So I have three answers to that. One is that it's uneven, and almost everything that we will talk about across the universe of lawyers, law firms, whatever the service enterprises are, it's uneven. Some are way better than others. Some are very focused and doing a great job, and others are doing less well. In general, I think the law firms are making progress. They're aware that the market wants change. They're aware that in some way that the market is restless and it feels like it's not being served well enough. But my most fundamental observation is they're not doing nearly enough. And they're not thinking fundamentally enough. Very few firms are really thinking about the fundamental elements of their business model, which are where the real change needs to occur. The way they think about serving the clients, the way they organize resources, how many human beings and what the backgrounds of the human beings needs to be, how much they use technology, how much they use third parties to work in collaboration with them, and certainly their financial model, the billable hour being at the heart of everything, is not consistent with the improvements that we need to make in delivering legal service. And then finally, the investment model. Law firms are not nearly in the place that they need to be to think about foregoing income in the short term, taking that money that they might distribute to the partners, and instead using it to build a better tomorrow and to do the things, including experimentation. A lot of investment in improving a business is experimenting with things you're not sure are going to work. And of course, in law, you never experiment in the sense of risking the client's interests, but you experiment with different ways that you might go about doing something, and that requires investment. And on those fronts, changing the fundamental model, I don't think law firms have made much progress at all.
Well, are you suggesting that the law firm model itself is archaic and needs to be changed in some fundamental way?
Yes. I mean, I wouldn't say it quite that way, but the model needs to be changed in a very fundamental way. That doesn't mean it can't be a partnership. Although I do think, as I testified to the California State Bar a couple of weeks ago, I do think we should permit investment in legal service enterprises, including law firms. But I think the partnership model can work, or some other kind of professional service organization can work. We need partners. We need highly experienced, highly trained expert lawyers in the mix, and certainly in the biggest firms. But the idea that the work needs to be done almost entirely by people who are licensed to practice law makes no sense at all. None. Right? The idea that the only capital you can have to support your organization is after-tax income of the people who happen to be partners in the firm doesn't make any sense at all either in the modern era, and including when you weigh the considerations of protecting the public against the considerations of creating the most vital legal service organizations.
Yeah, there's that old joke about I forget what it was, Richard Susskind or somebody said something about it's awfully tough to stand up in front of a room full of people who are making $1 million a year and tell them their business model is broken. Right. And I imagine you must have gone through this to some extent at Orrick, as you did try and push changes. That was a 100-plus-year-old firm at the point that you became chairman, and there must have been a lot of ingrained ideas about how we do things and how things should be done. So how do law firms confront the need to change and make that happen within their organizations?
So they have to lead. That's why law firms are headed by leaders. If they're going to be successful, they're not managing. This isn't being a foreman of a manufacturing organization where there's machine tools and there's tolerances you have to perform to. This is leading people who are independent professionals, and they need to be independent professionals. This is not just a partnership model question. Lawyers only are helpful to their clients if they say the thing that doesn't want to be heard, if they question ideas. That's what makes a great lawyer. So you have to lead. You have to have a vision for where we're trying to go and why we need to go in that direction, and you need to convince the people in your organization that they should follow that vision. And of course, you interact with everybody and the vision changes as you all work together, but you have to lead them. And the problem isn't just that they're making a lot of money. They're not all making a lot of money, right? The top financially performing firms are making a lot of money. But they're all really outstanding lawyers. All the successful firms are full of people who are really good at what matters to them most, which is being a lawyer. And those are the two things you have to overcome. They're making good money. They're really good at what they set out to do. And now you're telling them they need to change the way they go about it, the way they access information, for example, the technology that's available to help people improve the way they serve their clients, not just be more efficient, be better at it, because they've got a more complete understanding of the facts because they use the technology to get there. So you have to lead them to understand that that old way that did serve them well enough in the past is not good enough because they could do better, and they owe it to their clients to do better. It's not enough that you were good yesterday. Now, tomorrow you can be way better if you take advantage of what technology enables, what process design enables, what diversifying your workforce enables. If you put together a workforce that has some engineers in it and some people from different walks of life to bring new ideas to how might we persuade that jury, or how might we negotiate this deal, you're going to be a better lawyer. And so we have to lead people to see there is a better way. And of course, we need a thesis and a plan that delivers a better outcome for them, which I believe you can do. I believe the law firms that drive themselves away from the billable hour, think about their financial model differently, can end up not only charging their clients less than they otherwise would have, they can end up making more money and having better lives, the associates and the partners.
Yeah, but you and I have been around for a while here, and we've heard this end the billable hour conversation for a long time, and we're not making a lot of progress on that.
We're not.
How do we make that happen? Is the pressure going to come from clients? Is it going to come from outside sources, ALSPs, that sort of thing? I mean, how do we ever break out of that kind of rigid model and mindset around that?
So I think there will be more pressure from the clients. And I think Clock in particular will get better and better at thinking about what they should be demanding from their corporate clients. And they have so much buying power. They can influence what the law firms do. There'll be some of that.
Clock is the Legal Operations Consortium group that formed, 2 years ago now or so? And,
it's 5, I think.
5 years ago, yeah.
A little more. But so I think that there will be more pressure from the clients. But the leadership has to come from the firms. The firms themselves have this within their control. And I think more firms will see the benefit of this, because the benefit of getting away from the billable hour goes to everything, including one of the things that is top of mind for most law firm leaders today is how to attract and retain the talent they need. They're very concerned about the turnover, their inability to find the people, the inability of the law schools to attract people to new lawyers to even go to law school. And if they were to get away from the billable hour model and turn to a model that incentivized and rewarded new ideas and efficiency, they would find a workforce that liked their jobs better and was more stable, and everything in between. But I think the burden falls to the law firm leaders.
We'll get back to my interview in just a moment, but first, let's take a break to hear from the sponsors who generously support Law Next. And now, let's continue this week's interview.
So let me just ask you about a couple of the things that are going on in the world, in the legal world right now. I mean, let's start with regulatory reform. I mean, you just indicated that you did testify at the California task force meeting during the ABA annual meeting a few weeks back in San Francisco. What do you want to see happen there? What do you expect will happen there?
In California?
On the broad, across the landscape. Well, are we going to see, in our lifetime, are we going to see meaningful regulatory reform of the kind that I think you and I probably both agree we need to see?
Right. I wouldn't have had a crisp answer to that several months ago, but I now believe we are going to see change. I think, and Utah may be the catalyst, the leader in all of this, and Gillian Hadfield and her thinking about the sandbox is getting some real traction. But I think there are two dimensions where the change needs to come, and we've talked about them already in this conversation. One of them is liberalizing who can participate. So the set of people at work on behalf of the clients includes more than just the category of those who are licensed to practice law for all sorts of reasons, including bringing new ideas to the table, but also it affects the cost and so on. And the second is permitting investment in legal service enterprises. And that doesn't mean that law firms are going to go public. It simply means that you can access capital from other sources so that you can build an enterprise that doesn't have to make a lot of money every year because you have some capital to support you. It also means that you're able to share the benefit of the enterprise with others in the firm who are not themselves partners in the firm. Yeah. In the California discussion, this was one of the issues that came up that I hadn't given enough attention to. But permitting the income of the firm to be shared beyond the partners enables you to reward the others in the firm who are driving the success of the firm and the service to the clients.
So how does that investment, should that be allowed, get to the issue? I understand how it allows firms to make new investment and develop new technologies and get better at delivering legal services. But one of the sore points that I've noticed over the last couple of years is that so much of what we're talking about in terms of investment in legal technology is going to build legal technology to better serve wealthy clients. Mm-hmm. It's going to big law firms. It's going to big, AI intelligence for M&A, mm-hmm. for streamlining M&A, the process, or something like that. We're still not seeing enough investment going towards better serving those who can't afford a lawyer in the first place. So how does this regulatory reform, in your view, get at that issue, if at all?
Well, that's the main reason to do it. The social policy imperative is greatest when it comes to access to justice. Back what you were saying about the biggest M&A deals, those people don't need a new access to capital. There's a more sensible model than the big firms have that you might create, but they'll do just fine in terms of supporting their investments that they need to make. The real problem is it's almost impossible to create an enterprise that is successful and can serve the ordinary citizen with the issues that it needs to grapple with at a price that it can afford without some kind of investment to create an enterprise. One of the biggest problems we already touched on is that the individual doesn't really understand how law works, may not even know he or she has a legal question. They know they've got a personal question, but they don't know whether it's a legal question. And so investment is required to create enterprises that can make themselves known to the general population that doesn't normally deal with lawyers. So they know there's this resource there somewhere in the same way that they know there are other service resources available to them in other walks of their lives, enables them to sustain losses in the course of building the business, and then enables them to share resources across a large enough business model so that they can price at a fee level that is affordable to the individual and enables them to make enough money to make it worth their while, especially while we're in this period that legal education is so expensive and so much of the work has to be done by lawyers. The more we liberalize who can participate, the less pressure there will be on the economic model because you can do it more cost effectively.
Yeah. Back in your Orrick days, you established the first, insourcing operation in Wheeling, West Virginia, I believe. Right. It was a model that certainly a lot of other firms have since emulated in one way, shape, or form or another. Now we're seeing a lot of clients outsourcing a lot of work to ALSPs. Do you see ALSPs as a threat to established law firms, a challenge to them? I mean, how do you see ALSPs as affecting kind of the next few years in the development of the delivery of legal services?
Well, I think there's no logical reason, that our system should not permit other forms of organizations who are not law firms. I mean, law firms grew up at a different time and created the models they have. Why would we not permit other models to participate? So for starters, I don't think, though, that they are a threat to the law firms. I think they're symptomatic of a reality in the market. The market is restless. They're not in revolt, but they're not satisfied with the way legal service is being delivered to them in the ways that we talked about a moment ago. And so they're finding other ways. The fastest growing enterprise to deliver legal service is the in-house law department. That's growing faster than anything. Yeah. And that, in a way, maybe that's a threat to the law firms, but it's like a wake-up call to the law firms. And these alternative legal service providers, it's a very healthy development. And there's so much demand for legal service. There's plenty of work for all of the law firms and all of the alternative legal service providers to do. The one place where the expansion is greater than it should be is the in-house departments. These are cost centers in enterprises that's core competencies are doing what they do in whatever business they're in, and now they've got to go into the law business because it's too expensive to hire big law to do it for them in the way they used to do. The reason people in the AmLaw 100, 200 think that the demand for legal service is flat is that the market is choosing other solutions to the traditional one. Yeah. But I think there's plenty of room. There's so much demand for legal service and so much demand that goes unmet. I think there's plenty of room for everybody.
There's plenty of room, that's for sure. The question is getting those services to the people who need them, not to the people who don't need them.
And on that, right, for sure. So there's two, and the most pressing issue is access to justice. If we're really going to have rule of law in the United States, our citizens need to be able to use the legal system to defend themselves or assert their claims and organize their lives, all of that. And you can't do that if you can't afford a legal service solution. That doesn't necessarily mean it has to be a lawyer, but you need some help to deal with this incomprehensible system. So that's one thing. But on the corporate level, the clients need to push back more. I said this earlier, but I'm going to repeat it for emphasis. They need to push back more. They could get better service from everyone who was serving them if they asserted their buying power and if they were a little more ready to take a chance on a firm that isn't presently ranked as the number one law firm in the world, but is every bit up to doing what it is that they need done today. Take a chance on some of those other firms. This is one of the things I've learned about as I've dealt with smaller firms around the United States. There are great law firms in every region of the United States whose lawyers really can, in a very effective way, meet the needs of the most sophisticated corporate client. Yeah. And the clients need to get themselves the confidence to get beyond their traditional solutions and the easier way for them to do things and push for new solutions.
Yeah, I mean, my sense is that legal departments are more willing to do that. I mean, a few years ago, there was still that mindset that, I'm not going to be the one to hire that lower cost firm, and then we lose that case, and then it's my butt on the line. Now, I think legal departments are much more cognizant of exactly what you said, that you can get high quality legal services at lower costs from different kinds of providers, whether it's a smaller law firm or an ALSP or whatever it might be, depending on the matter. Much savvier about that. Our time is starting to run short here. We've been talking. I could sit here and talk all day to you, but we don't have. I don't have enough bits on my computer to record it all. But I wanted to ask you, what else is on your mind? What haven't we talked about that you're thinking about, watching, observing, caring about these days?
Well, we've touched on everything in law that I'm concerned about, including we just briefly touched on the need to reform how legal education works. Our legal education needs to prepare the lawyers of tomorrow in skills and areas of knowledge that it's just not very good at preparing them with. And so that's a very important issue. That's why I think the Institute for the Future of Law Practice that Bill Henderson and others have formed is so important, because it's a pragmatic way to create another set of elements of a curriculum that could be bolted on to traditional legal education. But I think that's also very important. The other thing that I'm concerned about is this question of creating rewarding careers for lawyers. I was inspired to be a lawyer by a vision of what it was like to be a lawyer.
You were a high school teacher originally, right?
Yeah, a sixth grade teacher.
Sixth grade
teacher, right. But Perry Mason inspired me. I wanted to be that kind of lawyer that would find the truth, and that would use the litigation forum to get the truth out and get the.
And we all know that's just exactly what it's like every day in real courtrooms, right?
Well, there's a lot of it in the best cases. There is a lot of that, but the day-to-day experience of the lawyer isn't that romantic idea that we had, and it could be more that way than it is today if we made some of these changes. We need to change the way legal education works, but more fundamentally, we need to change the reality of the experience of the young lawyer. I have a daughter who is just entered her third year of law school this week. And I've been living with her through the conversations with law firms and through the things she thinks about in deciding what to do next. And she correctly sees that so much of what the day-to-day experience of associates in big law firms is, that it's not very appealing. And she really did a lot of soul searching about what she really wanted to do and shopping among law firms before she made a choice. And that every law student, I think, has the same, more sophisticated, more informed outlook. And we need to change the reality in the law firms so that more people want to be lawyers in law firms. And then certainly we need to create a new reality so that people want to serve the public and the issue that you raised before in access to justice.
Well, I mean, one of the great inequities in the legal profession for those entering it as lawyers is the pay gap. And when I went to law school, the gap between going to work in a public service job and going to work at a big firm job was not anything. I mean, it was this gap, and you obviously make more money going to a big firm than you would going to public service, but it wasn't so huge that it basically left you no alternative about which way to go. I mean, now everybody wants one of those big firm jobs because they're saddled with all this debt, and they want to get rid of the debt, and they want to make some money. And it's harder and harder for people to make the decision to go into public service jobs. I mean, some schools have loan forgiveness for those who do and whatnot. But it seems to me that salary disparity between big firms and the rest of the legal world is a big part of what's maybe in some way contributing to the access to justice problem we have in this country.
No question, and especially since legal education is so expensive. If it weren't for that, if the legal education weren't so expensive, then this wouldn't be as big a problem as it is.
Right.
But it's a very big problem. And what those students more often than not, I think, decide is, I will go to big law long enough to earn enough money to pay off my debt.
Right.
And then I'll move on to what I really want to do
with my life.
Right.
Yeah.
So this is one of the reasons that we need to permit investment in enterprises that are going to serve the public. Because if we can create enterprises that can serve the public in a way that makes a profit, then that gap will still be substantial, won't be as substantial, because you can make a decent living serving consumers, individuals, in their legal issues. But right now, it's very hard to do that.
Well, Ralph Baxter, thanks for taking the time to be with me today on Law Next.
Yeah, it was a pleasure, Bob. Thank you.
Looking forward to the launch of your podcast, and I will be an avid listener to that.
Great.
Thanks again to the sponsor of today's program, MyCase. With thousands of customers, is a trusted practice management solution helping lawyers across the country run organized, efficient, and successful law firms. You can try MyCase for free today at mycase.com. And a big thanks, as always, to the guy who produces and edits this show, Ben Ambrogi. That's it for this week. This is Bob Ambrogi.